In the last few clips, I've basically have been showing you or walking you through some of the actual legal documentation. Now, the main one we're focusing on is the notice of objection to strike and order, and then I've got the actual date of the actual court date where the actual hearing happened at the district court before the judge, which was the 27th of February 2017. So that was the first hearing that I actually had my first oral hearing, half a day hearing before the judge at a district court where two counsels were there. The judge who took the hearing that day, this application that I'm walking you guys through, there's lots of good tips on it. You'll be basically just, walked you through what I did. However, my case has been sabotaged, so there'll be lots of evidence there to prove that my case has been sabotaged as I walk you through. But there's a lot of tips in this one legal document. In fact, this one legal document basically covers everything historically. The reason why it is long, it was contained, I think, 17-page long, but because it was two companies in one application, that was the reason why it was long. I'm going to be reading the cause of action for City Med Steve Colpin. So this here was an exhibit, and it was a report that he actually wrote, hence is the reason why I was unfairly dismissed. So that report became a document relied on, and it was number 4 on the plaintiff's list of documents. The medical report was written by Steve Colpin, dated the 19th of November. I've just narrowed it down. I mean, there was lots of things about the report that I could have written in here, but these are the things that I felt was relevant to mainly focus on. However, the report was written without my consent. I didn't consent to it. And I gave him no permission to write a report about my mental health without me being present. So we didn't have a one-on-one consultation at this point. To that day, I didn't even know at that time, I didn't even know what he looked like. So I'd never met this person. And I didn't even know what he looked like, this doctor. I was only told of him by management at the time I was going through the unfair dismissal process. So he wrote the report, and his report was he had taken obviously evidence from documentations given to him by the employer. Now at that time, the system, even for that, is completely different. They had separate people doing the investigation and writing the report, and then they had a manager who made the decision based on the report, and then they had a doctor by the employer, which is this person here. So that was the process at the time. The report was written without my consent. They did ask me for my consent to even contact my family GP, but I hadn't given that consent either. There were a lot of reasons why. In fact, what had actually happened, if I can recall rightly, because it was the second time that my employer had made me do a mental health assessment, going back to the report that was made on the 8th of July 2009, that report was written because my employer had asked me to go for that assessment. So at this time, because it was the second time I was asked to go for an assessment by my employer, I asked them to put it in writing, because I didn't say yes. I said I wanted to see in writing. I wanted them to put it in writing what they wanted me to do. Now, the reason why I asked that in writing, because the first time they made me go, for an appointment, and that was the outcome of that last mental health assessment. I didn't ask him to put it in writing. I was verbally advised to go by my manager. Of course, I didn't want to go, but at that time I decided, why not? I knew there was nothing wrong with me. I wanted to prove them wrong, and sure enough, nothing came out of that. But however, a report was written. Okay, so at this time, with this doctor, I wanted my employer to put it in writing, the reasons why they wanted me to go, because I wanted to read it. Also, I wanted evidence, so I asked them to put it in writing, their request. So they did put it in writing, and then when I actually read the report or the reasons why they were referring me, I declined. I said no, I'm not going. Just from reading what their intention were, and knew it had become really serious for myself. So I didn't go, and I didn't consent for anyone of the ministry to contact my family GP. But this is what the report is. But in this report, he's referred to me as the employee A, page 1, paragraph 1. The plaintiff is referred to as unqualified and unnamed employee A. So that's me he's referring to. B, page 1, paragraph 2. As requested, I have assessed this employee's health problems, their relationship to her past and current work, and my opinion as to ongoing management of the situation. C, page 2, paragraph 3. I have carefully and comprehensively read all of these documents and made notations regarding the sources and content of information that I consider to be important in making this assessment. D, page 2, paragraph 4. I have not examined or interviewed or had any contact with any of the persons involved, nor have I visited the workplace. This doctor's actually acknowledging in his report that he hasn't seen anybody, like a human body, obviously, or a one-on-one consultation with anyone. That's what he's meaning here. E, page 2, paragraph 5. That also consent has been refused for me to and her employee to contact her doctor or psychologist. So he's confirming that I haven't consented to it, because I didn't. F, page 3, paragraph 6. My summary of key points in respect of employee A and related matters, post-traumatic stress disorder, PTSD. It appears from reading all this information that employee A has long ago separated from her husband, and there may be some residue psychological issue as to problems with domestic violence in that relationship. If those past events were associated with that, could give rise to ongoing fears and anxiety and possibly symptoms of post-traumatic stress disorder, PTSD. This could explain the psychologist's 2013 assessment in respect of specific symptoms of PTSD causing increased anxiety. Commonly, PTSD symptoms are recurrent, intrusive of a past traumatic event's flashbacks of that event, distressing dreams of the past event, avoidance of stimuli to these memories, lowering of mood or raised anxiety, persistent distorted understanding of causes of past event fear and anxiety, sleep disturbance, disassociation, and these all may lead to poor personal, social, and occupational functioning. Delusions or false beliefs are not symptoms of PTSD. Page 8. My opinion referring to defendant Steve Colpin. A. Paragraph 5. In my opinion, I do not believe that employee A has a mental illness or consider that the most appropriate diagnosis for this is a psychotic type of illness, being a delusional disorder with persistent, non-bizarre, persecutory and referential delusions. I do not believe employee A is suffering from schizophrenia. Employee A has none of the other features diagnosis schizophrenia being hallucinations, disorganized speech, grossly disorganized, or catatonic behavior. B. I do not believe that these delusions and employee A's behavior at work are caused by or are part of any post-traumatic stress disorder. C. I am concerned that employee A's persistent delusions and her lack of insight into the fact that these are patiently false beliefs that are adversely affecting her personal and occupational functioning indicates that her illness is quite severe and needs some experienced specialist psychiatrist management and treatment to enable employee A to return to normal and acceptable cognitive and personal function. I just wanted to elaborate a little bit more on this one here, where he's actually acknowledged that the actual doctor that should be doing the mental health assessment is a psychiatrist. So he's acknowledging here that he's not a psychiatrist, and that the actual medical practitioner that qualifies within the scope of doing a mental health assessment on any human is a psychiatrist, and only a psychiatrist. But he's actually acknowledging in his report that he's not qualified to make a diagnosis on my mental health. D. In my opinion, the most important next step is to try and assist employee A to accept proper psychiatric assessment and treatment as needed. Without this, I fear that her symptoms will worsen, and I'm concerned that such illness in the long term may lead to more morbidity of the above diagnosis, would need confirmation and or amendment by a psychiatrist who is the appropriate skilled specialist in this area. E. I do not believe that a psychologist or counsellor is the appropriate primary person to diagnose and treat this disorder. He's gotten all this information from documentation. Number 2, Exhibit 7, an affidavit dated 19th of February 2017. Response to Dr. Steve Colpin's report. This is my response to his report. The question is that at the heart of this civil case, CIV 2016-090-000-890, is whether the defendant has acted on good faith as a medical practitioner. While the whole medical assessment report is fraudulent and not legal, the plaintiff has selected some paragraphs to particularly focus on several statements made by Dr. Steve Colpin. Dr. Steve Colpin's medical assessment report had fraudulent punitive damages. The defendant's report has caused harm and permanent damages to the plaintiff's reputation and character. This report clearly makes false, debarging, and derogatory statement about the plaintiff. The report reveals and proves that the following elements took place. 1. There has been a breach of contract. 2. The plaintiff did not consent to the medical assessment appointment, nor did the plaintiff knew what Dr. Steve Colpin looked like at that time. 3. As a result of the defendant Steve Colpin's report, the plaintiff was medically terminated from her employment of 13.5 years with the Ministry of Justice on the 1st of December 2015. 4. Defendant's cause of action in his written report was false and had defamatory statements about the plaintiff's mental health and medical capacity that were false and untrue. The report contains statements with the intent to cause harm or giving no care to the harm that was likely to be caused. 6. The report was written by the plaintiff on his own notion with malicious intent to destroy the plaintiff's reputation and character. Seven. This report elaborates on the plaintiff's past history of domestic violence with her ex-husband. This information is not even relevant during the employment with the Ministry of Justice of 13.5 years, as she has been divorced since 2006 from her ex-husband. Okay, so I was pretty upset that that was even in his report. I mean, I hadn't met the guy, so I don't know where he got that information. So there was like a lot in this whole report that really upset me, and I found it very, very, very upsetting and offensive. But as you can just tell from the information that I've pulled out that I felt was important to focus on, it clearly indicates that somebody who was trying to create a family violence, like actually shifting the blame away from the cyberbullying and the workplace problem that I was having onto family violence. I was not in any relationship with anybody. I wasn't like even having any contact with my children's father. We were separated, and he was, living his own life, and I was living mine. So I was pretty upset with the report. So I had to put in there as evidence my marriage certificate. I'd also put in there that I was divorced, because that's what that's the kind of evidence you need to submit. So it's basically just telling the judge, I don't know where he got the information, but it was inappropriate, it was wrong. So that's why I had actually put my marriage certificate and my divorce paper in there. In a sworn affidavit. I just wanted to confirm and verify a few things in regards to my marriage certificate and order of dissolving marriage, which is actually my divorce papers. So as you can see, I've put up there to refer to Exhibit 1 and 2 on affidavit dated the 6th of September 2016. On this affidavit, it had numerous exhibits of legal documentations. It was lodged with this affidavit dated 6th of September 2016. It had numerous documentations of legal documents and exhibits submitted in support of an interlocutory application to enter a summary judgment. Now, all this information were sworn documentations under oath. You have the choice to either affirm without a Bible or to swear on oath, where I always swear on oath, which is the Bible. In this documentation, I've asked the judge to refer to the order of dissolving marriage, which is actually called divorce papers. That's what it's another name for it. But in this affidavit, I had submitted legal documentations of my marriage certificate, divorce papers, birth certificates of all my children, and my divorce papers, of course, I already mentioned that. And also had submitted exhibits of 111 calls when I was in family violence situation with the children's father. It was just evidence to prove my background, keeping in mind, even though this time I'm only just painting a picture basically for the judge to see, it is my profile. But I wanted to, in support of the summary judgment, of the reasons why I knew I was eligible to have, a summary judgment entered in, and to also to reveal in support of what these doctors had put me through. And it was also evidence to prove that at this time, when all these things were happening with me with cyberbullying, I've had nothing to do with the children's father. It is my profile. I wanted to prove that that actually put me in high risk. The other documentations that was in this affidavit were the marriage certificate had the name of the church where I was married and the name of my pastor. Now I know that the church is linked into everything because that is where my foundation, my existence, my faith, my spiritual walk started. Basically, the legal document talks about my background. Now, also in this documentations, I had other documentations in there that were under my alias. So I had sworn on this affidavit that I was known and made known to court that I'm also known as an alias. So, all these kind of information is important. So then, they know that you are the same person. But I know with scams that have been going on, which is what's happened to me, people have done unlawful investigation and just build up a case. So that's a predicament I've been in. They've been digging up dirt and building up a case without my permission, without my consent, or without even for me to be able to defend legally before the courts whether what they believe they have upon me is true or correct. So also in this legal documentation, I'd also submitted that my ex-husband had mental illness problems, which, these are the kind of issues we had when we were going through family violence. The thing is, I'm proving that I've had a difficult life, I've had a hard life, and what everyone was doing to me was really serious, and they were endangering my life. He also had, a background of drugs and alcohol, but that was our situation. Keeping in mind, this was almost 20 years ago at this time. And this affidavit sworn 2016, so you've got to take it back from that time. But he was not even in the picture. I wasn't even in a relationship with him, nor was I in any relationship with anyone. What I was also trying to prove is that the evidence clearly indicated that I was subject to cyberbullying on documentations. Also, in this affidavit, there was a protection order. Things for me was that difficult. I had to get a protection order. When you're in that kind of circumstance, where marriages aren't working and it's just not working, I had to use the courts and I had to get out a protection order, which I used when I needed it at that time. So it got so bad that I had to finally made the protection order final. So that protection order became final. I made it final. So then I would always have that opportunity to ring the police and they would immediately come and investigate in case the children's father did a breach. For those who don't know, by a protection order, everybody uses it now, but a lot of people don't have an understanding of what a protection order is. Now, in a protection order, you can still have your partner and still have a protection order by the consent of the party, which means I can go to him, he can come to me, as long as nothing happens and I consent to it. So he could visit the children, I can go to him and we just have that civil adult relationship that you need to try and see if it's going to go anywhere or not when you have little children. So I ended up making that protection order final for the purpose of, there were times it just didn't work out and I didn't feel safe, not only for myself, but for the children. And I would use the protection order to make him leave. That protection order was in this affidavit dated 6th of September. I had put together my profile And then I was basically just giving the judges or the judge core evidence of my background, because you can't argue that when it's legal documentation. I was very black and white with my evidence, and it was my profile. I also had my citizenship papers in there to prove that. Number 8, this report was then used as evidence to determine whether the plaintiff had a mental health illness, and to also determine whether the plaintiff was fit to carry out her duties within her role as a court registrar officer, deputy registrar for the Ministry of Justice. 9, the defendant is not qualified to do any medical assessment on any patient. Because I have found out as time went on, this was confirmed in court too by their own counsel, that Dr. Steve Colpin is an occupational therapist and does sports medicine according to his website. So that is what I found out. And all this is in this legal document, and the judge has cited all this.